Okay, guys, so we're going to be talking about relevant facts. Please make sure that you watch this video in its entirety because it is absolutely relevant to your assignment for this week. We're going to be talking about legally relevant facts versus your background or your irrelevant facts when it comes to legal writing. We're going to break down what makes a fact legally relevant. We're going to talk about why it matters and how to distinguish it from any kind of unnecessary background details that aren't going to contribute to the legal analysis. And this is absolutely an essential skill. It doesn't really matter whether you are drafting a legal memorandum, you're writing a persuasive brief, or you're preparing a case for trial. It's absolutely very important because this is kind of the backbone of your case. So let's start with the basics. What are legally relevant facts? So in legal writing, not all facts are created equal. Some of them are essential because they have a direct impact on the legal issues, and those are going to be the ones known as legally relevant facts. They're going to form the foundation of legal arguments and help attorneys determine the strengths and weaknesses of a case. And a legally relevant fact typically does one of three things. It establishes an element of a legal claim or defense, it affects the application of a legal rule, or it impacts the determination of liability, damages, or procedural outcomes. So, for example, if a plaintiff is suing for negligence, then legally relevant facts would include whether the defendant owed a duty of care, whether that duty was breached, and whether that breach caused the plaintiff's injuries directly. So we're looking for that actual and proximate cause. If a case were to involve a contract dispute, then relevant facts might include like the terms of the contract, any kind of modifications, and whether or not a party failed to perform as they agreed. Without those facts, then legal reasoning would be incomplete. So they are the key puzzle pieces that allow us to apply legal principles and actually reach a conclusion. Now, on the other side, we have the background or irrelevant facts. So what are these? These are the details that might add some context, but they don't actually change the legal outcome. So they might be interesting or they might be emotionally compelling, but they don't actually contribute to the legal analysis. So, for example, let's say that you have a contract dispute and there is a business owner who claims that the supplier breached a delivery agreement, okay? The fact that the owner's favorite color is blue and that they take their coffee with like cream and sugar, that is completely irrelevant. It has absolutely no bearing on the legal dispute. However, there is a middle ground. Some background facts may be useful if they clarify a situation but should still be kept concise. For example, the fact that the plaintiff runs a seasonal business, that may be relevant if the contract breach is going to affect like peak sales periods, and that can impact damages. So in legal writing, our job is going to be to filter through the noise and focus on what truly matters. And a well-written legal document is precise, and it avoids unnecessary information that can distract from the core legal arguments. So let's put this into practice with a hypothetical scenario. I'm going to read through the situation, and then we're going to analyze which facts are legally relevant and which ones are not. Now, pause to read this if you want to, but I'm about to read it to you. Please take note, though, that this is going to be similar to your assignment for the week, and I'm going to kind of walk you through what's expected of you. Now, Alex, a 37-year-old accountant, was walking through a grocery store when he slipped on a wet floor near the produce section. There was no warning sign posted, and surveillance footage later revealed that a store employee had mopped the area but failed to place a caution sign. Alex suffered a broken wrist and required surgery. At the time of the fall, Alex had been on the phone with his mother discussing weekend plans. After the fall, he declined medical treatment at the scene, but later went to the hospital that evening. Alex's favorite food is sushi, and he was wearing a red jacket that day. The store manager later admitted that the store had experienced several slip and fall incidents in the past month, but had not changed its safety policies. So let's analyze this. Which of these facts are legally relevant and which ones are background or irrelevant? So let's start with the legally relevant facts. These are going to be the ones that are going to go into the legal analysis. So here's what we know. We know that Alex slipped on a wet floor in the grocery store. We know that no warning sign was posted. We know that surveillance footage showed an employee had mopped but failed to place a caution sign. We know that Alex broke his wrist and required surgery. And we know that the store had previous slip and fall incidents, but had not changed its safety policies. So these are the critical facts. These are the ones that directly impact Alex's potential negligence claim against the store. They established the duty, which is the duty of the store they have a responsibility basically to keep the customers safe. There was a breach of this duty. There was a failure to put up the warning sign, and there was causation. He slipped on the wet floor. And then there's damages. There's the broken wrist and the need for surgery. So now let's look at the background or irrelevant facts. Alex is a 37-year-old accountant. He was talking on the phone with his mother. He declined medical treatment at the scene but sought care later. His favorite food is sushi. And he was wearing a red jacket. These facts right here, they don't actually change the legal analysis. So whether he was on the phone, it doesn't actually affect the store's liability unless it somehow contributed to his fall, which is unlikely. His clothing choice doesn't matter. It's entirely irrelevant. And his preference for sushi, maybe we'll call this one interesting, but it doesn't actually have a legal significance. Now, the fact that he declined medical treatment at the scene, this might be mentioned for context purposes, but what ultimately matters is the fact that he sought the medical attention and he confirmed that he has an injury. So now let's look at we'll call it a revised version, because part of your assignment for this week is to break down the facts, the irrelevant facts, the relevant facts, and support your decision on just the relevant facts. And then I want you to give me a revised version of the hypothetical. You don't necessarily just take out the facts that are irrelevant. You can if it does it cleanly, but you might have to reword some stuff. So let me show you. Alex was walking through a grocery store when he slipped on a wet floor near the produce section. There was no warning sign, and surveillance footage later revealed that a store employee had mopped the area but failed to place a caution sign. Alex suffered a broken wrist and required surgery. After the fall, he later went to the hospital that evening. That should have some words taken out. I mean, talking about the fluff words for this week. This is a good lesson to go back to the grammar, but I digress. The store manager later admitted that the store had experienced several slip and fall incidents in the past month, but had not changed its safety policies. So this is what a kind of a cleaned up version looks like when you remove all of that stuff that doesn't matter. And I know that on the previous slide, like I said, that you can add in that he declined treatment at the scene, and you can add that in here. I just went ahead and kind of removed it because, again, it goes back to the fact that he ultimately did seek medical attention, even if it was, later. Anyhow, so let's talk about why this skill is so important. When it comes to legal writing, remember that every word has to serve a purpose. Judges, attorneys, clients, no one has time for those extraneous details. Okay. So writing that is clear, it's concise, it's focused, and it's on all of the legally relevant facts. That is going to be something that is persuasive and it's effective. Okay. It prevents miscommunication, and it also ensures that, any kind of key legal issues are going to be front and center. Now, one of the biggest mistakes that law students and new legal professionals make is including too much information. So remember that just because a fact is true doesn't mean that it belongs in your legal argument, okay? Instead, ask yourself, does this fact impact the legal outcome? And if I remove this fact, does my argument actually change? If the answer is no, then it's irrelevant. So Again, your assignment is to take the new hypothetical case, to identify the legally relevant and irrelevant facts. Remember to justify your choices. But this is part of helping to train like your legal reasoning and your writing skills. And also make sure to include the issue statement. In fact, please read the hypothetical first, create the issue, and then look for the facts that are going to be tailored to that specific issue. And then next week, we're going to we're going to continue building. And then basically, we're going to take all of this and we're going to expand it into an appellate brief and into a trial brief. So let me know if you need anything, and I will be happy to answer any questions. Bye.